Um, Good afternoon, everyone. And welcome back to our fifth installment, our fifth and final installment of the International Law Summer Institute's guest faculty lunchtime lecture. And today we have my friend and colleague Jutta Brunnée. I'm going to introduce her in a minute, but because this is the last session, I just actually wanted to say a few words about the Institute. And this was a collaboration between the CIGIs International Law Research Program and the Balsillie School. And it really couldn't have been put together without the financial support from CIGI and the great logistical, moral, and intellectual support from the Balsillie School. And so Sarah and I, pardon me? And SSHRC, yes, and we got, and the federal government. And so Sarah and I just wanted to convey our thanks to all of the people who made this week run very, very smoothly, particularly from CIGI, Mona Davies and Blaney and Tiffany Bradley and Joanne Weston from the Balsillie School, who have been working really tirelessly behind the scenes to make this a really sort of seamless week. So thank you, and on with the show. I think it's wonderful that we're able to end this week with Professor Brunnée. Professor Brunné's work over the last 15 years, particularly her collaboration with her colleague Stephen Toop, has really become, I think, a very central and interesting part of the discussion around some of the key questions we've been discussing this week. How we understand international law, the role of international law, how we think of international law as being binding, why states comply with international law. And so I think this is a nice way. We sort of started with a bit of theory, and now we're, I think, coming back to that on the last day. So Professor Brunnée is a professor at the University of Toronto Law School, where she holds the Metcalf Chair in Environmental Law. Her teaching and research interests are in public international law and international environmental law. She's the author a co-author with Stephen Toop of Legitimacy and Legality in International Law, an Interactional account, where they set out most comprehensively their interactional theory of international law. That book was awarded the American Society of International Law Certificate of Merit. She's also the co-editor of the Oxford Handbook on International Environmental Law, which, if you're an international environmental lawyer, you tend to keep no more than 10 feet away from you at any time. And she's been very engaged as a member of the ILA's Committee on Legal Principles relating to climate change, and she was recently elected in 2013 as a Fellow of the Royal Society of Canada. So it's a great pleasure to introduce Jutta Brunnée.
Thanks, Neil. It's great to be here, and very nice to see this group of people. Neil and Sarah and I have been corresponding a little bit about the, how all of this would unfold and what the role of the lunchtime speakers would be, and so on. And I kept asking them curious questions about who would be here, and they said, "We don't know. We're building this." And so it's great to see you all here. And even nicer for me also to see some former students of mine and former U of T students here who in various capacities have ended up here. And in fact, Neil is one of them. He was my doctoral student, and I'm delighted to see that he has turned as white-haired as I. So I don't know whether that makes me look younger or you older, but we'll just leave it at that. So very brave to leave the theory, the full-on theory, to the last day, but I hope to also leave you with a sense that theory can be not just interesting, but also practically relevant and important. When I came into the panel, unfortunately a little late, but I had enough time to look on the board there, and I saw that you had a fast tour through the main theories of international relations. So that's actually very nice background for what I will be talking about, although my focus will be mostly on international law. So I'm here actually to talk to you in a way. I'm taking advantage of this opportunity because I'm talking about what is a somewhat preliminary effort to map out a bigger project that I am working on with Stephen Toop on stability and change in international law and some big questions in international law. So this and the kinds of reactions I will get from you are all going to be very useful in that context, because at this point we're not actually quite sure on exactly how we will frame the project and which direction we take it, what examples we use, and so on. So, stability and change in international law. Well, first of all, what do we hope for in international law? And we might say that we hope that it provides stability for international society, right? That it provides the ground rules for international relations, that it tempers raw power through the rule of law, that it maintains international peace and security, and that it balances an international economic and trade system, some of which I guess you've talked about yesterday. You might also hope that it makes the world a better place, that it actually can somehow help bring about change, positive change, so protect human rights, provide accountability for international crimes, provide solutions to climate change, facilitate international investments and protections for investors, and so on. So that's the hope. What do we fear when we think about international law? Well, I suppose many people would say, well, we fear that it actually cannot provide stability because it in itself is inherently unstable, fragile, and fluid, and that it can promote change because it is too unstable and too weak. And the common theme of both of those fears, or what underlies those fears, you might potentially recognize from your discussion this morning, and that is the perspective that it is states' interests and relative powers that are actually the main drivers of the international system, and that international law has no power, that it doesn't have staying power or shaping power on its own. Well, I think it's fair to say that the hopes for international law that I just mentioned are too optimistic. Law cannot, by its mere existence, make the world a more stable and better place. It can help with that, but it can't accomplish that. At the same time, I think dismissing international law the way that I've caricatured it a moment ago is also far too pessimistic. International law can, as I said, help promote stability, and it can have a positive impact, and I would put to you that it does matter in international affairs. After all, states, international organizations, NGOs think so. Why else would they make lots of it? And why else would people generally think that their countries should comply with it? I was actually interested to find by now, this is maybe not entirely up to date, but there was a 2009 survey by worldpublicopinion.org, and they found that most people in 17 of 21 nations surveyed said that their government should abide by international law and rejected the view that governments are not obliged to follow such laws when they conflict with national interest. And by the way, that included the United States. 2/3 thought the US should comply, and 1/3 had a different view. So, well, I'm a lawyer by training, so I'm not equipped to make any sort of causal claims about the extent to which international law promotes stability or facilitates change in the world. My hunch is that it does, and that is why we keep making it and why we keep believing in international law. So I want to be slightly less ambitious in what I talk about here today, and I want to be less ambitious than inquiring into the impact of international law in the world. Rather, what I want to focus on is the role of stability and change in international law itself. And so what I want to explore today are the following three questions. First of all, how does international law mediate the interplay between stability and change? Second, is international law stable? And if so, why? And then lastly, when and how does international law change? Now, there's a fair amount of writing on the interplay between stability and change in domestic law, especially in the common law literature. In fact, law is commonly associated with order, predictability, certainty, and so stability. But since law operates within society, of course, it also has to change, right? As social values evolve, or new social, economic, technological, or environmental challenges and opportunities arise. And arguably, that's where the circle closes. Without such change, law cannot provide stability over time. Now, that basic point, I think, applies to international law just as to domestic law. And now, to be sure, when you look at the literature, there's a lot of commentary on grand themes of change in the structure and content of international law. And I think you've talked actually about some of these in your week here. That is, for example, exploring the rise of new actors, the emergence of new substantive areas like, say, environmental law, or human rights law, international criminal law, and so on. But what I was surprised to find when I started thinking about stability and change in international law and how international law mediates between the two, there is very little work done by international law scholars that engages directly with these dynamics of stability and change in international law, or with the broad range of devices through which law manages these dynamics. In fact, now I'm not sure whether I should be encouraged by this or thinking, oh my God, I better get on with it, because now there is, surprisingly, inquiry in this. In fact, there's a big volume, special issue of the Netherlands Yearbook of International Law coming out all about temporality in international law. So it seems like there is something there. Well, so why has there been so little inquiry? Well, one could speculate perhaps it's because by many, it's perceived by many as constantly changing and inherently unstable. And although on the other hand, if you look at some recent work in Europe and the European Journal of International Law, Joost Powellen, and Geneva-based international law scholar and colleagues published an article where they posit that change is happening not because international law is too unstable, but because it imposes shackles. It's too rigid. It actually hinders change, and so increasingly states and other actors are looking to bypass it and get work done in other ways. Well, that's a different conversation. Well, in any case, this sense that international law is unstable because it's contingent on interests and power and so on might explain why international lawyers at least have sought to stabilize it through emphasis on formal sources like treaties and custom, and constructs like jus cogens, the idea that there is non-derogable law out there, and projects like constitutionalization. Be that as it may, so what interests me here for the purposes of this talk and in the project that this talk is part of is this underexplored, I think, terrain on the inside of international law. So what does that mean? Well, the core of my argument is the claim that a particular approach to mediating between stability and change is inherent in fact, is characteristic of legality and the rule of law, and that actually applies in international law as it does in domestic law. And so to get at law's distinctiveness and to understand the specifically legal interplay between stability and change, we have to look at its internal structure. That's the first point. The second point, important in my framework, and if you looked at the readings that were provided, you will have seen this, a crucial point is that legality must actually be practiced. And that's because law is not just a thing that simply exists in the world and that does things or not. It is, to paraphrase constructivist international relations theorist Alexander Wendt, international law is what we make of it. I'll come back to this idea. So making international law, generating and maintaining legality requires hard work and sustained hard work. It's very interesting. I, at one point, Stephen Toop and I wanted to call our book on legitimacy and legality, The Hard Work of International Law. The publisher said, are you nuts? That's not a book title that would make anybody want to buy that book. Just last week, we had a workshop in Toronto on this project, Stability and Change, and one of my colleagues did say that she thought we should downplay the hard work part because people wouldn't want to hear that. We should make it sound fun. Well, the point is that we have to keep at it. You have to do it. You have to take it seriously. You have to practice international law. So in this 2010 book, that is in a sense sort of the basis, the foundation for where we're going now, Stephen Toop and I develop an understanding of international law that brings together a particular strand of legal theory propounded by a prominent US legal theorist, Lon Fuller, and constructivist international relations theory. And that we bring together into what we call an interactional account of international law. Now, constructivism, you heard a little bit about that, I take it this morning, helps us, we think, illuminate how shared norms emerge and how they shape social interaction. And practice clearly is central here. Right? From Lon Fuller, we get a set of so-called, what we call criteria of legality, I'll come back to those, that help identify distinctive traits of legal norms. And we argue that the distinctive effect of law has to be generated and maintained through practices that sustain legality over time. That's the hard work or the fun part or whichever that I just referred to. So in short, we have three interrelated elements here: shared understandings or social norms, criteria of legality, and then what we call the practice of legality. And we think that this framework can help us understand the relative stability of and also the need for change in law, and that it can help us understand the distinctive interplay between stability and change in law that I've referred to. Now, let me try to explore a couple of angles here. First, I want to say a little bit more about why we're interested in stability and change in law. Then I want to give you a bit more of a sketch of this interactional account of international law. And then I want to return to the questions 1, 2, and 3 that I started with. That is, how does international law manage or mediate stability and change? Is international law stable, and when and how does it change? So I'll try some tentative answers out on you. So first of all, stability and change in international law and interactional law. Now recall the pessimistic views about international law that I mentioned at the outset. So at the risk of caricature, I will overstate them. International law isn't really law, or at least it's weak because it's not enforced. What really matters are states' interests and their relative power. And when push comes to shove, when international law bumps up against interests or power, it loses. Either it won't be made in the first place, or it won't be complied with. Now, that view of international law, even though, again, it's a caricature, it's an overstatement, but I think it's still relatively common among international relations scholars, and in particular within rationalist IR theory, about which you've heard a bit this morning. And that is because that strand of theory focuses on understanding states' actions and conduct as driven by rational pursuit of interests. Interestingly, that view is also quite common among international lawyers. In fact, I would venture to say that this dominant perspective, rationalist perspective in international relations, and the traditional international law framework reinforce one another. That is, many international lawyers accept the proposition that rational pursuit of interests and powers are the key drivers of international action. And in turn, the often dim view of international law in IR is fed by the dominant conception of international law as a construct that we find by tracing it to certain sources, that is, treaties and so on, and an understanding of law as hierarchical imposition of authority. And because the latter is largely missing in international law, it's weak, right? Or it's not really law. So in this view, then, international law has no inherent stability. It's contingent on interest and power, and it's stable as long as those driving forces are stable, and it'll change when they do. Now, what animates my work with Stephen Toop is the intuition and, in fact, the claim that these views underestimate international law, that they focus on what you might think of as the surface of law. It's a treaty, it's a statute, it's this, it's that, and on external factors like interests and enforcement, and that they neglect to think about and look at the deeper structure of what makes norms law and what then, in fact, mediates between stability and change. And so our intuition was that law's distinctiveness cannot be all about pedigree, that is, what source is this rule from, hierarchy or force. And that is how we became engaged with constructivist international relations theory. Now, why constructivism? Well, at some level, because it validated our intuition that norms matter. And more than that, though, it explained how norms emerge and change. Right? It's all well and good to say they matter and they change, but how do we understand how that happens? And the answer is, roughly speaking, through social interaction. Right? And then how do they matter? Well, eventually, these norms come to frame social interaction, and they begin to shape how actors see the world around them and themselves and their interests. So for constructivists, norms and actors are actually socially constructed, hence constructivism, and in more fancy language, the agents, the actors, and the structures, that is the norms and the institutions, are mutually constitutive, right? One doesn't completely determine the other. They're in a sort of cyclical, iterative interaction. Well, the underlying proposition that norms are constituted by social practices and that social practices are shaped by norms doesn't imply, actually, perhaps surprisingly, that there can never be relatively stable norms. It simply highlights the fact that I already pointed to, and that is stability also is produced by and dependent on practice. So stability, perhaps paradoxically, is dynamic. It depends on practices. Well, however stable many international norms may be at any given time, they can be shifted through evolving practices and through processes of contestation. And that's an insight I would put to you that applies to codified legal norms, like treaty norms, and to customary norms alike. That notion is fantastically unsettling, right? Especially for lawyers, but perhaps for other people as well. The famous person on the street, because we like to think, we find it reassuring to think about law as a fixed, stable thing that we know when we see it and that we can rely on. But then when you think about it, it's also common sense, right? So ironically, we're back to actors, but there is a fundamental difference here between when I say stability and norms and all that depends on the practice of actors. That's different from the rationalist interest and power-driven account that I sought to get away from. So in that account, you will recall, law itself is not stable. It's completely dependent on external factors, interest, relative power, and so on. Constructivism invites us actually to see law itself as a social practice. And so it acknowledges that both stability and change are produced by that practice, and in this case, by law, at least in part. Now, if that's right then, and if law is a social practice, and if legal norms are, at least at some level, social norms or are rooted in social norms, how do they differ from other social norms? And how does legal interaction differ from, say, political interaction? So that's where I come to the interactional legal theory and the three interrelated elements that are already flagged. So I think that this framework suggests some answers. So the first point that I made, again, is that building on constructivism, our argument is that legal norms can only arise ultimately in the context of social norms that are based on shared understandings. And such shared understandings emerge, prevail, evolve, fade, are stable, or change through processes of social interaction and social learning. So as I just suggested, both stability and change of norms depend on social practice, point number one. Second, of course, not all social norms are legal norms. There is a difference. But what distinguishes law from other forms of social ordering, we suggest, is not, as I said, pedigree or hierarchy or force, but adherence to specific criteria of legality. And that's where we draw on the work of Lon Fuller, who identified 8 such criteria, which lawyers would typically also recognize as indicators of the rule of law, if you will. So let me run those past you. Legal norms have to be general. That is, they can't be just ad hoc decisions that apply in this case, but not in that case. They have to be promulgated. That means they have to be accessible and knowable to the public so that actors can know what the law enables them to do or asks them to do and so on. Law should not be retroactive so that people can actually take it into account in their decision making. It has to be reasonably clear so that actors can understand what's permitted, what's prohibited, what's required, and so on. It should avoid contradiction, so Rule A shouldn't say do this, and Rule B says do that, and it's impossible to do both. It should be realistic and not ask impossible things. And its demands on actors should be relatively constant over time. And then finally, Fuller suggested there also needs to be congruence, what he called congruence between the rules that exist as law and official action. Now, you'll recall the hypothesis that law mediates stability and change in distinctive ways. Let me now build on that proposition and suggest that these requirements of legality that I've just mentioned are at the heart of this distinctive mediating. In fact, I would suggest that it is these requirements and not the fact that law is written down, for example, codified in the treaty and so on its own at least, that these requirements account to a significant extent for law's relative stability because they promote stability and guide or even constrain change. So let me illustrate. Generality, clarity, and constancy over time each address the need for predictability and so stability of the law. The requirement that law not ask the impossible, I think, also fosters stability because unrealistic demands do what? They prompt noncompliance, right? And sooner or later, if you get a lot of noncompliance, you unsettle the law. Promulgation, I think, can also promote stability and facilitate predictable and orderly change. Non-retroactivity and non-contradiction actually guard against a particular type of change, right, that makes it difficult to know what the law wants us to do. And then lastly, this requirement of congruence, we're puzzling through this. And we had a lot of debate last week about what exactly we mean by this. But our hunch is that this requirement is of a slightly different quality. That is, the other criteria of legality that I've mentioned, they capture specific ways in which law manages stability and guides change. But congruence is actually what reveals what it takes for law to be stable and helps explain how it changes over time. Because congruence, in our view at least, connects to this third aspect of the interactional law account, and that is the proposition that these criteria of legality aren't just a checklist. You draft a treaty and you say, okay, my rule is general. It's not retroactive. It's this, it's that. That's great, right? That's where you should start. But norms that meet these criteria also have to be and have to remain embedded in what we call a practice of legality. That is, the application of law, the interpretation, the arguments that you make on the basis of law have to respect these criteria of legality as well. And so if I put it much more simply, these norms have to continue to be treated like legal norms. And that, we think, is a crucial dimension to law, because without sufficiently dense interactions between participants in the legal system, positive law, what's on the books, will be dead letter. And that's where we are going with this idea that law is a distinctive type of social practice. So in other words, congruence highlights that stable practices of legality are required to maintain norms as law, and lack of congruence can erode the law. Now, I want to just pause for a moment and say that although the criteria of legality favor stability, we want to emphasize that, at least we don't think that this framework is inherently conservative. That is, that it somehow stifles change. In fact, first of all, the particular form of legal stability that we describe is rooted in interaction. And so it's an open system allowing for the participation of a range of social actors. Second point, the criteria of legality that promote stability require transparency and accountability. In fact, Lon Fuller once said, if you practice legality or if you adhere to these requirements of legality, you have to do your work with the fists, not the elbows. It has to be visible. It forces actors to be clear and consistent and so on and transparent about what they do. So that facilitates contestation, we think. And then third, the stabilizing tendency of these criteria of legality is modulated by the requirement that the criteria and all law are grounded in shared social understandings. And that means that legal normativity has to be constantly maintained through this practice of legality. And in fact, we would say that the discipline that is created through these criteria allows for or facilitates a predictable and reliable framework for promoting substantive change and potentially also for the evolution of what is often referred to as soft law. So again, the key point in all of this is that these practices of legality are required to maintain norms as law, and lack of congruence, lack of this practice leads to potentially the erosion of law, and maybe part of the practices that eventually produce new normative understandings and shift the law. So we've come to think about this idea of congruence, and that's the part that we have to figure out much more as the pivot point for the rule of law, that's really the key to how it all works. Now, in our work, and I think a little bit in the, I don't know what was circulated, but in the brief discussion paper that I sent to Neil and Sarah, so what we're doing is we're looking at how customary law and treaty law do this differently or relate differently to this framework. And that's ultimately where the project, when we roll it out in full, will have to go. And our initial hunch is that when we think about customary international law, that we will focus a lot more about the interplay between shared understandings and the requirements of legality, and think about how international practice enables and disciplines the dynamics of custom. And as a sort of initial hunch, our sense is, for example, when we think about the requirements of legality, that generality might be a strong point of custom because it requires widespread practice, right? And it applies to everyone, but things like promulgation and clarity might be weaker. So it doesn't necessarily score high or equally high on all these criteria. Now, in treaty law, we are interested especially in these requirements of legality and the extent to which these requirements permeate treaty law and practice. And what we found interesting was that when you look at the Vienna Convention on the Law of Treaties, which is basically the codified reflection of the customary law of treaty making, how are treaties concluded, when do they enter into force, how can they be changed, and that you could map virtually every single provision in this Vienna Convention on the Law of Treaties on one or more of the requirements of legality. And so our hunch is that the structure of treaty law has this stability promoting and change guiding feature to it. So now, after listening to me so far, you might say, well, that's all very interesting, but what's the point? Well, so in truth, we're still organizing our thoughts about this and where exactly this goes, and that's precisely why I am interested in your feedback and thoughts and even gut reactions. But there are a few possibilities, I think, which address the three questions that I began with. That is, how does international law mediate between stability and change? When and how does international law change? And is international law stable? So let me leave you with a few sort of preliminary claims that we have come up with. The most modest claim would be that the requirements of legality promote stability and guide change, and that's especially evident in the context of treaty law. Second one, related but perhaps a little bit more ambitious, is the idea that law mediates stability and change in distinctive ways through these requirements of legality. And that the interactional law framework helps us see that more clearly. I might maybe push this a little bit more and say, for a norm to stay legal when it changes, it has to respect these requirements of legality, right? So you can, for example, say, well, today the rule is blue, tomorrow we make it yellow, just like that, right? And there's different ways in which we could illustrate this, but that we can make that change from blue to yellow, but we have to do it in a way that is promulgated, that is general, that is and. Right? Third, more provocative point would be that we provide here, or at least that is what we're hoping to get at, the beginning of an explanation of why interactional law, so not international law in the traditional sense, but our account isn't as fluid as many may think it is because it's so practice-focused, right? So many people have said, how can this work in the real world if everything is just always in motion? So what I've just laid out for you, I think, shows how an interactional understanding of law actually explains stability perhaps better than an account that says, well, here's our treaty, it's all written down. Of course it's stable, right? Because it doesn't account for the practice that occurs pursuant to that treaty. And so the flip side then is that the conventional account might overstate what stability, for example, codification can provide, and understate, come back to my initial point, how resilient law can actually be in the face of interest and power. And then fourth, and perhaps most ambitiously, I might claim that these interlocking elements of the interactional account, so shared understandings, criteria of legality, practices of legality, that they provide a theory, or the foundations of a theory of stability and change in law. That's where we're really going out on a limb. But roughly what I have in mind there is that when you think about the elements, shared understandings, criteria of legality, and practices, we've actually come up with a sort of circular image. Not that everything is always in a circle, but it's not linear, right? It's not that you make law, you draft it, you're done, and it ends. That precisely our point is that the hard work of international law is never done. When you've adopted a treaty, then you have to bring it to life, so to speak, develop it, practice it, and so on. So, but what we have in this image then is an element in the idea of shared understandings, the constructivist discussion that I touched upon at the beginning, shows us and helps us understand how social norms emerge, stabilize, and shift. Right? So that means that there is an element that's potentially dynamic. And if we have dramatic shifts in social norms, we can then start to think about what that might mean for law. Now, when I link this idea of social norms to the criteria of legality, social norms can become what I called relatively fixed as law, but that fixity isn't really permanent, right? So again, I would posit that when the shared social understandings in which legal norms are grounded erode or shift significantly, law will likely be under pressure to adjust. And for example, stability and change of social norms, I would say, are important contextual factors for legality because they have bearing on clarity or reasonableness. Something that seems reasonable today may be completely unreasonable in light of how our social understandings have changed. For example, a lot of press right now about Caitlyn Jenner. So there's a lot of, gay marriage, whatever it may be, right? So we can think of examples in the domestic context. So the theory then is that there is pressure that is exerted on these criteria of legality, and if law wants to maintain its legality, it'll have to adjust. But the criteria of legality then are the stabilizing element because they constrain and guide how that change can occur so that the rule that we're dealing with is still law when all is said and done. And then lastly, the congruence criterion, or this idea of the practice of legality, highlights once again that stability is dynamic, and that it's only through this continuing practice of legality that existing norms are supported. And when that practice fades away, when actors no longer comply with the rules or no longer uphold it, the norm may erode. Now, I want to be clear, congruence and practice of legality isn't the same just as compliance, right? You can have, in international law, you often have non-compliance, same in domestic law. That doesn't mean that the law falls away because actors aren't adhering to it. If nobody does, of course, eventually you will have a problem, right? But there are different ways in which you can practice legality. Non-compliance is what one actor may do, or a couple of actors, depends on how the others react to that, right? And how they push back. So in international law, an example that we use in our first book were attempts after 9/11 on the part of the United States to play around with the definition on the prohibition of torture or to expand the definition of self-defense. And that didn't actually occur in the end, even though a fairly significant actor was pushing in that direction. So I guess, you know, as may be somewhat evident, I haven't completely worked this out, which is what makes this exciting to me, at least. But the idea is that social change can exert pressure on legality, and it may lead to a lack of congruence and vice versa. But we have stabilizing elements here as well. And so that doesn't mean that we're throwing overboard everything that you've read or know about international law and how important, for example, treaties are. Treaties may, in fact, lend themselves to instantiating a lot of these criteria of legality. Our point is simply that just writing it down isn't going to do for you what you're hoping for. So this is, as you will have seen, a theoretical project, but as we did in the first book, and this hopefully will also result in a book, we tried, in the first book, we mapped our account, or we tested it in 3 areas: prohibition on the use of force, prohibition on torture, and climate change. And so we're planning to do something similar here, to look at actually how this plays out in particular examples, to illustrate and to hopefully find that it is plausible and pull back if we find that it is not. But as a very sort of preliminary matter, I might say you could take some of this and apply it when you design a treaty regime, for example, right? You could make room for the development of shared understandings, for example. You could pay attention to these practices of legality that I've described, and so on. So there are some very practical takeaways. If nothing else, a caution that the lawyers shouldn't pack up their briefcases and go home when the treaty is adopted and signed and ratified, but they have to stay plugged in and take it seriously. And I guess a last note, and this connects to what Sarah said about non-state actors. Now, the main activities remain, or many of the main activities in terms of lawmaking continue to be among states. But what this account also suggests is that everybody potentially actually has a place in this, in holding states' feet to the fire, for example, and making these arguments for legality and against this or that action, or in trying to shift social norms and so on. So I will leave it at that, and whatever you want to do now, we can do. Well, not quite, but.
So I think we have some time for some questions. So Jutta, I'll just let you.
Okay.
Hello. Thank you so much for this presentation. A lot of what you said really resonated with me, and I'll certainly be reading more of your work. The thought for me is that, or my comment, I guess, is that your sort of theory of how law can change is a very iterative theory, you know? Law changes in iterations as social contexts change. But, I mean, the real burning question is whether or not the international legal, or international law as it stands in or the whole international law regime, as I would, I guess, imagine it, can change fast enough to deal with something like climate change, especially coming from David Estrin's presentation the other day. Yeah. Because, you know, right now the globe isn't changing in iterative steps. So, yeah, and you mentioned that climate change is a part of the project, so I'm just wondering if you can elaborate more on that. Thanks.
Well, so climate change, I suppose, is a perfect example or a perfect illustration that having a treaty doesn't solve the problem, right? So there was great fanfare when the Framework Convention on Climate Change was adopted, and then even better when the Kyoto Protocol was adopted, and so on. There's a number of things to say about the climate regime. So I remain, after having followed it for, I don't know, as long as it takes for hair to get this color, and maybe that's part of why. I remain interested in it. In fact, I was involved in climate negotiations for Canada. It's by now quite a long time ago, so I have, some degree of affection for the regime, and I think that it is important that there is a global climate regime. And I know David Estrin has probably a slightly, or my hunch is that he has a slightly more, I don't know what I should put as a label, skeptical view about the regime. So a couple of things. So I think what you can say about the regime is that it suffers from the lack of shared understanding. So it actually is a good illustration of what I've talked about here. And it shows that without, you don't have to have shared understandings about every little thing, where this comma is or that comma or whatever it may be. But for some fundamental things, there has to be a shared sense about. I do think there is a shared understanding actually among all countries, although strained, especially after Copenhagen, that a universal regime, one that involves all states, is an important thing. And that's because it's not just as simple as saying, let's get the 8 biggest emitters do their thing, because what they do impacts on everyone else, right? So it seems that it makes sense for this to be a global regime. So that, I would say, is agreed upon, and the convention itself starts with that proposition, right? Climate change is a common concern, and all states have the common but differentiated responsibility to participate in an effective blah, blah, blah. Now, common but differentiated responsibilities is an illustration of where there's been a lack of shared understanding. And there again, I would say, in the book, the first book, we actually trace this in quite some detail. You can show that there is, some of that norm is actually shared ground. I think, again, there is shared, there's an agreement that it is a common responsibility to participate. The prize question is differentiate. Yes, that's also agreed, but how and on what basis? And I won't go into all the gory details, but I could trace out for you how over time the regime has suffered from the fact that, overstating the point, developing countries have adhered to one understanding of what common but differentiated means, and the North from a different one. Roughly speaking, the South has tended to say, it means that you do and pay for everything, and we do things, but we don't have to actually do anything about our emissions for X, Y, and Z reasons. And the Kyoto Protocol is sort of the illustration of that, right? Whereas the North has tended to say, well, we agree, we have, larger capacity, we should take the first step, and so on, but we can't actually solve this problem without universal action, and differentiation should happen not just between South and North, but more widely according to much more flexible criteria. And what's really interesting, since the sort of beginning of the talks about post-Kyoto, now post-2020, you can trace in the climate negotiations concerted efforts by almost all of the parties to either defend their understanding of common but differentiated or to shift it. And now it has shifted, right? And again, I could give you a very detailed account of this, but it has actually shifted. And with that comes a structural shift as well, in that you now have this idea that we cannot actually agree. Common but differentiated doesn't mean we have an acknowledgement now that all states will be in the same instrument. We still don't know exactly what it's going to be. But we now sidestep the issue in a way because contributions are going to be nationally determined, right? And then the last element that I would just highlight is another area where there was a lack of shared understanding is the objective of the regime is to avert dangerous concentrations of greenhouse gases in the atmosphere, but it took more than 20 years to arrive at an agreement on what that actually meant. And only once you could put that in relation to a temperature goal, you could put it in relation to a concentration of greenhouse gases in the atmosphere, which then allows you to extrapolate what we actually have to do to get there. And you can debate whether the 2-degree goal is right or wrong. I think there's actually another shift happening now in the sense that we're moving toward decarbonization and net zero emissions, right? That's the rhetoric, I think, that is the longer term shift. And so I'm watching this with great interest because it really actually illustrates what I've described. And it isn't that the law can fix it for us. the law is what we make of it, right? But what the law has done is it has created very strong procedural understandings that allow the parties to interact in certain ways with some problems, consensus decision-making being one. But you can see I could give a whole lecture on climate change, so I'll stop here. I think if I go by order of hands, it was you next. Sorry, I'm pointing fingers. And then over here, yeah.
Thank you for the presentation. I have a methodological question. And so I would just like to kind of paraphrase first to just make sure I understand. So norms change the way we understand stability and change itself. That will impact on how we look at legality. But in the end of the day, the criteria of legality is a stabilizing concept that will guide those norms, if I understood that correctly.
Yeah, so what, if I just jump in, so what we're trying to be careful about is we don't want to be understood as articulating a theory of change or stability in international affairs. We're not, that's, we're not trained to do that, and that's like, that's, I think, a can of worms. What I think we have to do more of is to identify, or at least sort of provide a kind of categorization of different drivers of change, and there is a literature about that. But the rough point is what you suggest. So it could be a change in a social norm that puts pressure on the law, but it could also be a change in scientific understanding. So if I take climate change, we now understand that unless we do X really fast, Y is going to happen, and we didn't know that last year or something, right?
So then to the question, then I'm wondering, what law are you talking about, in the sense of, is it the same law that goes all the way back to Christendom, or is it a genealogical thing that you're only speaking about the current regime? So are we talking about the universal?
Our person?
Are we talking about the universal, or are we talking about contingency?
Okay, so this is a question we get a lot because our approach is constructivist and talks about norm change, and yet we if I overstated, we essentialize these criteria of legality. So, and we've been, if you look at, I think you were given from International Theory this little introductory piece, is that right? The readings? I can't remember what you sent around. Yeah. So there is this is a little mini symposium on our book, and one of the commentators, Christian Reyer-Smith, makes a version of the point that you just make. And the criticism is that law is historically contingent and what we understand law to be. So if we are serious about our framework, we have to acknowledge that these criteria of legality aren't just given. And so I guess our answer to that is that's right. They are also, in a sense, part of what is shared, but they have, so one of the things we're debating actually is whether we should do a bit more work to substantiate and trace out since when they have been practiced in this way. So I can't say that 500 years from now that's what law is going to be, but as an observation of what underpins international law today, I think it's right. Now another caveat is that we believe that because these criteria are, in a sense, they're not about thick substantive values, right? So they don't presuppose that we protect human rights, that we are for equality of men and women or anything like that, although some people would hypothesize that if you take them seriously, that's where they lead you. If anything, the values that underpin them are autonomy, think state sovereignty at the moment, or and communication. But they what we think is that these criteria enable precisely actors with very different priorities to interact legally because they don't have to agree on what the good life is at the outset, right? And that means because actual shared understandings in international society are thinner rather than thicker, we often will have relatively procedural interactions, and maybe in certain areas we can go further. But the caveat is that we haven't done nearly enough work to think about how this maps onto, say, an Aboriginal understanding of law or Islamic understanding of law, and. All we can say is that in international practice, you can observe these things being valued. Does that sort of answer it, more or less? Okay.
Couple of questions, actually. One on the notion of stability, especially in international law. Is it an absolute, or is it, as in economics, predictable change is okay, it's part of stability? And so is it the same notion internationally? Second question, I get constructivism, especially when it comes to understanding domestic law. But domestically, we also have institutions that mediate power and leadership. I mean, not everything arises from the desire of social norms to make something change. Sometimes you change ahead of the curve, sometimes power groups prevail. And I meant to ask you how that translates into the field of international law.
Those are both great questions. The first one, I think, is actually one that I just wrote it down. I think at this workshop we had last week with colleagues from law and international relations, we talked a lot about what do we actually mean by stability, and they were pressing us on what do you mean when stability is dynamic, and. So that's the value, to come back to the theme that you've explored here, of interdisciplinary engagement, right? Because in one discipline we take for granted that what we do is important and just makes sense. But then somebody else says, well, but tell me how law matters, right? Lawyers tend to just assume that. Others don't necessarily. And so these methodological questions that's where the engagement is helpful to us. So I would say, as roughly speaking, so what we have to do, I think, is be more clear, and this will come out, I think, once we think about what sort of case studies or context we will choose to explore this. For example, are we interested in change over a long period of time or very short periods of time? And on your question, are we interested in the stability of law as the thing that continues to guide the interactions? I think my hunch is that that's the stability we're interested in, although we might explore why certain norms change within that larger context. But what you say about predictability, that's exactly right, except it will be a predictability guided by these criteria of legality. But that's the whole point, that change is okay, but you can't just say, today we like this flavor, tomorrow we like that flavor. That would be a change, yes. And you could do it in advertising or whatever, but not through, if you want to use law. In fact, Lon Fuller, in the very short little book, The Morality of Law, has this chapter about King Rex, a well-meaning but somewhat clumsy ruler who wants to make law. And Lon Fuller in the book illustrates the importance of each of these criteria by Rex making a mistake each time, by just saying, today we're going to do this, or saying the law is secret, only I know what it is, and so on. So that's roughly, I think, the answer to the first question, the institutions. So I mentioned earlier this iterative or circular diagram. We've actually inserted another element that we, as yet unspecified or not sufficiently concrete yet, we call it principles, mechanisms, and processes. So yes, institutions matter, and what we also want to explore is how, so custom, for example, is the quintessential horizontal legal interaction, very diffuse. Treaties are more structured, in part because of the treaty rules that we have, and in part because climate negotiations, for example, happen within an institutionalized context. And then there are courts, right? So how does the institutionalization impact on all of this? And do certain types of institutions allow for more change, for example? So in courts, you could think that who gets access to courts, whether non-state actors, for example, can make submissions, will have a dramatic impact on what the courts end up doing, and so on. So there's a lot there, I think. I'm again pointing. First, the lady with a purple T-shirt, and then the gentleman in the stripy shirt.
Thank you. Thanks for a very interesting talk. I'm interested in how we've been talking about international law and the politics around it. So how does power come into play here? Who has the power to
Yeah.
push the law through,
Yes,
to dictate the norms, and if there's any accounting of that in the interactional model. So I'd be interested in that.
Great
you.
question, and that is also one we get a lot. And last week we discussed that as well in great detail. So I could, again, give you a very long answer. I'll try to be brief and just highlight a couple of things. So first of all, so I want to be clear that the interactional account and the idea that law has to be grounded in shared understandings, that doesn't mean that we have rose-tinted glasses on and everybody's going to go happily ever after into a more orderly future. Far from it. In fact, I think if you take it seriously, it illustrates why that is not happening oftentimes. It makes visible that when we say we have this treaty where we proclaim that the international community blah, 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 why that may not actually, why that may be just a piece of paper. Now, I think, so again, this is an area where I think we have to go further in our case studies to play through so I think you have to distinguish between actors in the system, states, there are more and less powerful states, you could say off the top of your head that it seems obvious that powerful states with a lot of resources have more ability to shape understandings and to drive things forward, to maintain, practice legality, and so on, right? That's the case, I think, in any account of international law that you could think of. And again, climate is a great example. You have the United States arriving with 200 delegates. They can cover every single room and negotiate everyone into a corner, and then you have Ivory Coast coming with one person who's not a lawyer. It's right there, right? However, there are ways around that with alliances, negotiating alliances, and whatnot. So, so that I think you have to acknowledge. At the same time, we've had recently a sort of back and forth with Marty Koskiniemi, who's a critical international law scholar, whose most recent work deals with the culture of formalism, where he says that law is basically a formal platform on which actors hash out their political differences, but ultimately, whether you're after values or just pursuing your interests, it's always going to be politics that drives things. Again, I overstate and caricature this a little bit. What we're trying to suggest as well, but a culture of legality is more demanding than a culture of formalism, because what I've described here means that even powerful states can't just say what they want. They have to do it in a way that adheres to these requirements if they want to be persuasive and if and it makes it visible, right? So again, you can think of many examples where some of which I've mentioned about the US after 9/11 and so on. And so that means, in principle, everyone has the ability to shape the underlying social understandings and to uphold legality and to push back on legality. And so that means, for example, that Amnesty International is very important when they write respected reports about what happens wherever it may be and what powerful states do. The International Committee on the Red Cross came out with a study on customary law and international humanitarian law a number of years ago. Very interesting study. The whole point of it is to show that there's a number of treaties on humanitarian law, but not everybody has signed and ratified all of these treaties. So they want to show what of that is custom. Why does that matter? If it's custom, every single state in the world is bound, right? And before they get to specifically showing whether rule X or Y is custom, they go through the methodology of how they determine whether something is custom. And I think it's a great coverage of how we determine whether custom has come into being. On some issues, they go out on slightly a bit of a limb, although I would actually happen to agree with them. So for example, that you can rely on what countries say if you're looking for practice, and that you can infer that the opinio juris is present when there is a consistent and widespread practice, and so on. none other than the legal advisor of the US State Department at the time thought that important enough to disagree and write an article where he went through how that methodology was off. So all this to say that non-state actors can actually make, I think, a significant difference, and what this framework shows is that legality creates a space for this and forces transparency and accountability. It's not perfect, of course, right? But I think all sorts of actors can do it.
Well, thank you very much. I think this is a very exciting perspective on the very interactive aspects of international law. My two questions, one is partly asked by the lady in front of me, but it had to do with the two pairs of premises on which you're trying to explain the interaction and the internal stability of international law. The question of shared understandings and the congruency from Fuller's criterion for legality. One, of course, is that my problem with the constructivist account of how change occurs on the international plane is really to discount the asymmetries of power relations, which I'm glad you are able to explain, because the assumption of shared understanding assumes maybe a more neoliberal Western democratic social setting. But if I can take the example of, for example, the international criminal law, particularly the Rome Statute, and eventually creation of the Rome Statute, we could assume that many of the African states that signed to the Rome Statute had a shared understanding of what criminal responsibility would entail at the international plane. But when the International Criminal Court started to use African countries as a pigeon to test the viability of that institution, many African countries begins to say, no, that's not what we think to have understood. Yep. But I think that was largely because, in my perspective, many of those countries were socialized from the constructive perspective into signing into the treaty, but they were more powerful, mainly colonial powers. Economic power was always used, actually, to persuade some of those countries to assign, to get the 60 numbers required for the statute to come into force. So I think, but I'm happy, as you answered her, I think you demonstrate that you are, the asymmetries of power relations are very critical to understand that. And two, in explaining the congruence aspect and maybe the more interactions, correct me if I'm wrong, I seem to get you're focusing on the actors as states in practicing actually what the law states and bring into the day-to-day lives. But how do you explain this in the context of other non-state actors? The Islamic State, now it has, whether we like it or not, it has there. But everything it does flies in the face of international law. Or how do we, especially in the context of accountability within the international legal framework, vis-a-vis non-state actors involved in open warfare with a state? Take the example of Israel, a Palestinian or Hamasi conflict. The focus is always more on, for example, Israel as a state, but those non-state actors who violate the very rules of war can use civilian places, use even civilians as shields. We seem not to address that, and the international focus is on a state. So often you find Israel get the beating as the bad guy who is not following international rules, and then we carve this image that the others are basically victims, when actually one might say all of them are actually victims of an international structural system that is embedded again in asymmetries of power and interests. So anyhow, thank you.
Okay, well, that's a bundle. So on the first one, I would say, so again, I think if we had a longer conversation about power and building on what I said in response to your question, I think we would also be able to see that certain norms in the international system are already in a way biased because of, so that's, you know, so they are, so you're right in saying that part of the normative framework that then shapes interactions is skewed in a certain direction. What I'm suggesting, though, is that there is still, agency is still possible, and that legal interaction is one place where that can happen and where justification can be forced and so on. The ICC in particular is a really interesting example. In fact, we're thinking about using that as an illustration, and because, so from an international lawyer's perspective, it's ironic that when you talk to law students, for example, who are interested in international law, they think international criminal law is great because there's a court and there's, you know, there's accused and defendants, and we can actually, we have a court that hands down, and it seems like real law, right? And so part of our account is again to say, well, look again, right? The trappings of what looks like law, sure, it's not that it's not law, but it masks the fact that there is a gap between what we've written down. And so I would actually, don't know whether you meant to say that African states were socialized into joining. I think they might have been pressured into joining to some extent, right? Maybe a bit of both. But what the court has to do is to make that edifice become real. And one of the problems actually for international criminal law, especially the ICC, is when you take my criteria of legality, is generality, right? Because where does the court mostly focus? Yeah, so I think there are some really big issues. So you can look micro, do they handle an individual case well? And more macro, that raises much bigger issues. Then in terms of congruence and who matters, so again, this is a topic we discussed last week at great length, and that's a core issue for us, and I can't profess to have the answer, but whose practice matters? I think it is fair to say that in the international system as it exists at the moment, the states are the primary players. However, there are any number of entry points for other actors to participate in the shaping or participate in upholding international law and so on. What you describe is a different kind of actor, right? We've seen this, not quite, but we've seen it, a variation. Say North Korea would be the closest example on the state level, right? An actor that just doesn't want to play and says, this doesn't mean anything to me, and what do we do then? And so here, this is an extreme example, and it's an actor that sort of plays with elements of the international system, calling itself the Islamic State, but then is potentially, depending on where this goes, right, shifting what we understand a state to be. I suspect that's not going to happen that quickly, but this is not insignificant, although you see states doing the same thing. I think it's Estonia, for example, that has e-citizens. So when we think about the criteria of statehood in international law, territory, population, stable population, blah, 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 all the things that we can now do with cyber radically potentially shift these things that we've taken for granted. So here, what you actually see is because this actor is not, it's not possible to hold them accountable and have them play by these rules. It's basically states retrenching in a way to reassert the interstate rules on the use of force, and it creates a lot of difficulties because combating effectively those actors, if there even is a way of doing that, means by definition trampling on any number of the rules of the interstate system. So this is, I think though that this isn't so much about our account as, or not only, this is for any international law account. And it's precisely what you get when you have an actor that wants to subvert, in fact, take advantage of the system. But I would put to you, you find the same in domestic law. That doesn't undo domestic law, that you have people who say, oh, it's okay if I kidnap and kill these people and ask for ransom or whatever people do, right? David?
Thank you, Professor. One quick question, if I may.
Oh, okay, then.
The focus on a lot of the questions, and indeed in your presentation, has been on the public side of international law. But one thing that strikes me is that the model you've elaborated over the years applies with some very striking effect on certain elements of private international law, and in particular, the explosion of international arbitration involving states, particularly bilateral investment treaty arbitration. Could you perhaps speak to the degree that in your case studies you're perhaps considering that side of international law?
So first on, does it apply elsewhere? So we could say that so actually what's interesting, I think, well, that doesn't come out right. What is intriguing about drawing on Fuller to come to an understanding of international law is that Fuller was a domestic law theorist. Right? And so the general sort of stereotypical view is international law isn't real because it doesn't look like domestic law. Fuller's work was all about showing that all law is horizontal, right? So the reason that he emphasized congruence was to say that the lawgiver, the state, has to actually adhere to these requirements of legality if they want the law taker to be guided by law and respect the law and do their bit. It's interactional. It's actually more horizontal than the hierarchical structure revealed. So all this to say that I think you could use, so we did in fact use this framework to come up with an account of public international law, but I think you could use it, you could find law in any number of settings using this framework. And one of the things that we also do is to show that not all treaties, for example, are necessarily interactional law, but some soft law may be, right? So it's a lens that is sort of more open-ended. Some legal pluralist would say, and it doesn't, it could be industry that creates things that are interactional law, and the same applies to private international law. So that's more on the theoretical end of things, or conceptual end of things, but specifically the answer is yes. Investor state is actually, so it's a variation on what you just said about ISIS and the non-state actor. Here you also have non-state actors involved in the international legal system in a way that sort of pushes the envelope, and one can surmise that in each instance that is going to result in change of some kind, right? So we are thinking about investor-state disputes and investment law for that reason. Okay.
Thank you. Sorry. I just wanted to say a very, very warm thank you to Professor Brunnée for having given us that absolutely fantastic talk, which I think was just the perfect culmination of our series of talks this week. I think that really brought everything together and, in a sense, back to our first day as well. So thank you. Exactly. Thank you so much. That was truly wonderful.
International law, and I think you've talked actually about some of these in your week here. That is, for example, exploring the rise of new actors, the emergence of new substantive areas like, say, environmental law, or human rights law, international criminal law, and so on. But what I was surprised to find when I started thinking about stability and change in international law and how international law mediates between the two, there is very little work done by international law scholars that engages directly with these dynamics of stability and change in international law, or with the broad range of devices through which law manages these dynamics. In fact, now I'm not sure whether I should be encouraged by this or thinking, oh my God, I better get on with it, because now there is, surprisingly, inquiry in this. In fact, there's a big volume, special issue of the Netherlands Yearbook of International Law coming out all about temporality in international law. So it seems like there is something there. Well, so why has there been so little inquiry? Well, one could speculate. Perhaps it's because by many, it's perceived by many as constantly changing and inherently unstable. And although on the other hand, if you look at some recent work in Europe and the European Journal of International Law, Joost Powellen, and Geneva-based international law scholar and colleagues published an article where they posit that change is happening not because international law is too unstable, but because it imposes shackles. It's too rigid. It actually hinders change, and so increasingly states and other actors are looking to bypass it and get work done in other ways. Well, that's a different conversation. Well, in any case, this sense that international law is unstable because it's contingent on interests and power and so on might explain why international lawyers at least have sought to stabilize it through emphasis on formal sources like treaties and custom, and constructs like jus cogens, the idea that there is non-derogable law out there, and projects like constitutionalization. Be that as it may, so what interests me here for the purposes of this talk and in the project that this talk is part of is this underexplored, I think, terrain on the inside of international law. So what does that mean? Well, the core of my argument is the claim that a particular approach to mediating between stability and change is inherent in fact, is characteristic of legality and the rule of law, and that actually applies in international law as it does in domestic law. And so to get at laws the way that I've caricatured it a moment ago is also far too pessimistic. International law can, as I said, help promote stability, and it can have a positive impact, and I would put to you that it does matter in international affairs. After all, states, international organizations, NGOs think so. Why else would they make lots of it? And why else would people generally think that their countries should comply with it? I was actually interested to find by now, this is maybe not entirely up to date, but there was a 2009 survey by worldpublicopinion.org, and they found that most people in 17 of 21 nations surveyed said that their government should abide by international law and rejected the view that governments are not obliged to follow such laws when they conflict with national interest. And by the way, that included the United States. 2/3 thought the US should comply, and 1/3 had a different view. So, well, I'm a lawyer by training, so I'm not equipped to make any sort of causal claims about the extent to which international law promotes stability or facilitates change in the world. My hunch is that it does, and that is why we keep making it and why we keep believing in international law. So I want to be slightly less ambitious in what I talk about here today, and I want to inquire, or I want to be less ambitious than inquiring into the impact of international law in the world. Rather, what I want to focus on is the role of stability and change in international law itself. And so what I want to explore today are the following three questions. First of all, how does international law mediate the interplay between stability and change? Second, is international law stable? And if so, why? And then lastly, when and how does international law change? Now, there's a fair amount of writing on the interplay between stability and change in domestic law, especially in the common law literature. In fact, law is commonly associated with order, predictability, certainty, and so stability. But since law operates within society, of course, it also has to change, right? As social values evolve, or new social, economic, technological, or environmental challenges and opportunities arise. And arguably, that's where the circle closes. Without such change, law cannot provide stability over time. Now, that basic point, I think, applies to international law just as to domestic law. And now, to be sure, when you look at the literature, there's a lot of commentary on grand themes of change in the structure and content of
Good afternoon, everyone. And welcome back to our fifth installment, our fifth and final installment of the International Law Summer Institute's guest faculty lunchtime lecture. And today we have my friend and colleague Jutta Brunnée. I'm going to introduce her in a minute, but because this is the last session, I just actually wanted to say a few words about the Institute. And this was a collaboration between the CIGIs International Law Research Program and the Balsillie School. And it really couldn't have been put together without the financial support from CIGI and the great logistical, moral, and intellectual support from the Balsillie School. And so Sarah and I, pardon me? And SSHRC, yes, and we got, and the federal government. And so Sarah and I just wanted to convey our thanks to all of the people who made this week run very, very smoothly, particularly from CIGI, Mona Davies and Blaney and Tiffany Bradley and Joanne Weston from the Balsillie School, who have been working really tirelessly behind the scenes to make this a really sort of seamless week. So thank you, and on with the show. I think it's wonderful that we're able to end this week with Professor Brunnée. Professor Brunet's work over the last 15 years, particularly her collaboration with her colleague Stephen Toop, has really become, I think, a very central and interesting part of the discussion.
Fast tour through the main theories of international relations, so that's actually very nice background for what I will be talking about, although my focus will be mostly on international law. So I'm here actually to talk to you in a way. I'm taking advantage of this opportunity because I'm talking about what is a somewhat preliminary effort to map out a bigger project that I am working on with Stephen Toop on stability and change in international law and some big questions in international law. So this and the kinds of reactions I will get from you are all going to be very useful in that context, because at this point we're not actually quite sure on exactly how we will frame the project and which direction we take it, what examples we use, and so on. So, stability and change in international law. Well, first of all, what do we hope for in international law? And we might say that we hope that it provides stability for international society, right? That it provides the ground rules for international relations, that it tempers raw power through the rule of law, that it maintains international peace and security, and that it balances an international economic and trade system, some of which I guess you've talked about yesterday. You might also hope that it makes the world a better place, that it actually can somehow help bring about change, positive change, so protect human rights, provide accountability for international crimes, provide solutions to climate change, facilitate international investments and protections for investors, and so on. So that's the hope. What do we fear when we think about international law? Well, I suppose many people would say, well, we fear that it actually cannot provide stability because it in itself is inherently unstable, fragile, and fluid, and that it can promote change because it is too unstable and too weak. And the common theme of both of those fears, or what underlies those fears, you might potentially recognize from your discussion this morning, and that is the perspective that it is states' interests and relative powers that are actually the main drivers of the international system, and that international law has no power, that it doesn't have staying power or shaping power on its own. Well, I think it's fair to say that the hopes for international law that I just mentioned are too optimistic. Law cannot, by its mere existence, make the world a more stable and better place. It can help with that, but it can't accomplish that. At the same time, I think dismissing international law
around some of the key questions we've been discussing this week. How we understand international law, the role of international law, how we think of international law as being binding, why states comply with international law. And so I think this is a nice way. We sort of started with a bit of theory, and now we're, I think, coming back to that on the last day. So Professor Brunnée is a professor at the University of Toronto Law School, where she holds the Metcalf Chair in Environmental Law. Her teaching and research interests are in public international law and international environmental law. She's the author a co-author with Stephen Toop of Legitimacy and Legality in International Law, an Interactional account, where they set out most comprehensively their interactional theory of international law. That book was awarded the American Society of International Law Certificate of Merit. She's also the co-editor of the Oxford Handbook on International Environmental Law, which, if you're an international environmental lawyer, you tend to keep no more than 10 feet away from you at any time. And she's been very engaged as a member of the ILA's Committee on Legal Principles relating to climate change, and she was recently elected in 2013 as a Fellow of the Royal Society of Canada. So it's a great pleasure to introduce Jutta Brunnée.
Thanks, Neil. It's great to be here, and very nice to see this group of people. Neil and Sarah and I have been corresponding a little bit about the, how all of this would unfold and what the role of the lunchtime speakers would be, and so on. And I kept asking them curious questions about who would be here, and they said, "We don't know. We're building this." And so it's great to see you all here. And even nicer for me also to see some former students of mine and former U of T students here who in various capacities have ended up here. And in fact, Neil is one of them. He was my doctoral student, and I'm delighted to see that he has turned as white-haired as I. So I don't know whether that makes me look younger or you older, but we'll just leave it at that. So very brave to leave the theory, the full-on theory, to the last day, but I hope to also leave you with a sense that theory can be not just interesting, but also practically relevant and important. When I came into the panel, unfortunately a little late, but I had enough time to look on the board there, and I saw that you had a